Is an inventory search of a vehicle unconstitutional? To find out, you have to read People versus Douglas, but it's 16 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of People versus Douglas. The citation for this case is 2023, New York Slip Opinion 05350, published by the New York Court of Appeals on October 24th of 2023. The issue in this case is whether the New York City Police Department's inventory search protocol is constitutional. To understand and appreciate the context of this case and where it fits in, you have to know a couple of things in terms of background. First, that the Fourth Amendment to the United States Constitution prohibits unreasonable searches and seizures, and that basically cases have held that when law enforcement want to search something, when they want to search a property, a person, reasonableness generally requires that they obtain a search warrant. So that the basic requirement is for a search warrant generally. And that puts a neutral magistrate, a neutral and detached magistrate between the law enforcement that's seeking the search and the actual search taking place. That neutral magistrate then analyzes the allegations that would justify the search to determine whether a probable cause exists to find the things that would be sought by the search warrant. There are certain exceptions to the search warrant requirement. They include consent, search incident to a lawful arrest, plain view, things like that. One of those exceptions, and this is the last thing you have to know, is the inventory search. An inventory search is a search of persons or automobiles designed to catalog the contents of the item searched. And there are three specific objectives that an inventory search has to meet. Number one, the objectives are to protect the property of the defendant. Number two, to protect the police against claims of lost or stolen property. And number three is to protect the police and the public from dangerous instruments. So those protocols for an inventory search must limit the discretion of the officer in the field, and that's what an inventory search is. Okay. What are the facts here? The facts are that in October of 2015, two New York City Police Department officers saw the defendant commit multiple traffic infractions. They pull him over. They discover a gravity knife in his pocket, which is a crime, and arrest him. They then bring the defendant to the precinct to lodge him, to arrest him, and they bring his car also to the precinct to be searched from an inventory search. So they conduct an inventory search of the car, during which they recover a firearm, which is another crime. So the officers who conducted the search did not make a contemporaneous list as they went through the car. Rather, what they did is they took a plastic bag and they went through the car and put the things that they were taking from the car in the plastic bag, brought it back into the precinct, put it on the floor, and basically 11 hours passed between the time the search took place and the time the items were vouchered, meaning that they were given to the property clerk and a voucher was given back to the officers for those items that are now being lodged in a secure property clerk room. The police then vouchered the firearm and other items, and they charged the defendant with having that firearm. He moved to suppress the firearm, saying that you didn't properly obtain the firearm. This inventory search was unconstitutional because it gives the officers too much discretion in conducting the search. At the suppression hearing, the prosecution offered the written protocol into evidence, which is 218-13 of the New York City Police Patrol Guide. The Supreme Court, who was hearing that suppression argument, denied the application to dismiss. The defendant ultimately pled guilty with a sentence of 6 years jail and 5 years post-release because he was a predicate felon. And the appellate division then affirmed on the appeal. The appellate division affirmed the judgment, saying that it was constitutional, and it goes to the Court of Appeals. And here we have a majority decision and a dissent by Judge Rivera. The majority goes through everything I said about an inventory search. There are three primary objectives that an inventory search must achieve, that the point of an inventory search is to accomplish. And they say that although it's not up to the court, they say it's not up to the court to craft a better way of doing an inventory search. Basically, the people have an obligation to meet a constitutional minimum, just a threshold level at which those three objectives are met, and there's sufficient lack of discretion of the officers to conduct the search. And they say, well, in this particular police patrol guide protocol, which is 218 of 13, it instructs the officers to search the vehicle. It tells them the 10 areas that they must search. It directs them to open trunks, glove compartments, etc. If it can be done with minimal damage. Requires officers to remove the valuables and invoice them. And that's sufficient. That is sufficient, and it's therefore constitutional. So the majority rule is that it is constitutional. It's not a violation. But you do have a dissent from Judge Rivera, and she says it is unconstitutional. Why? Because she says it gives them too much discretion. It does not tell them that how much time that can pass. So in this particular case, 11 hours passed between the seizing of the items from the vehicle and the vouchering. And in those 11 items, there was a bag left on the floor of the precinct, sometimes possibly unattended. And that does not achieve those goals of protecting the defendant's property, of preventing claims of theft, and of protecting the public. And because there was too much discretion, and there's not a specific part of the protocol that says how the officers must actually conduct the vouchering with respect to how soon it's seized, she would find it unconstitutional. But once again, the majority decision here is that it is constitutional, meets the bare minimum threshold of achieving those goals sufficiently. And that's the case of People versus Douglas. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.